Well, good afternoon, Michiganders. It is Tuesday, October 18, 2022, and this, of course, is Tuesday with Tom. And no, I'm not coming from you before a live studio audience, just having a little bit of fun with the computer this afternoon. But we are Michigan's only weekly podcast where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome, welcome, welcome to today's program. Just a note before we get started today, Amanda and I have scheduled a number of both estate planning and estate settlement seminars, actually going to be in the form of a webinar beginning in October and through November. So I encourage you, head on over to Doyle Law PC, click on the seminar tab, and join us as we talk about basic estate planning as well as estate settlement issues. Last week's episode, be sure you understand the projected federal death tax and gift tax rates for 2023 and 2026. Tax laws and the federal tax laws are changing yearly because of changes that had been made a number of years ago, where we are now having different rates, be it the federal estate gift tax and unified federal estate tax rate, or how much you can give away in any one year. They're basically going up. Again, it looks like for 2023. And projecting out to 2026, there might be some significant changes for those of you who have higher value estates. So if those concern you, I encourage you to listen to last week's episode where I review both what the projected tax rates are looking to be in 2023 as well as 2026. Today's show, do you know how to manage your inherited IRA? But please remember, what I'm about to discuss during the program is, as always, to be legal advice. As always, you need to work with your attorney and your tax advisor, because we're talking taxes today. Need to work with your attorney and tax advisor to determine what is appropriate for you and your estate plan. Do you know how to manage your inherited IRA? We deal with a lot of clients today that are receiving an inherited IRA, oftentimes from a parent. So it's important to know the inherited IRA rules and deadlines so that you can best avoid or at least minimize taxes and avoid penalties on an inherited IRA that you would receive. So here are a few things that you should know about the inherited IRA. First, required minimum distribution. You need to know when you are required to make minimum distributions from the inherited IRA. If the deceased owner, if that is the person who owned the IRA, has already been taking retirement accounts. So let's say your father is already taking required minimum distributions from his IRA, and then he passes away, and you are going to receive that IRA as an inherited IRA, you need to make sure that dad's final distribution in the year of his tax death is taken in order to avoid upwards of a 50% penalty on the amount that was taken. So you still need to make sure that even though you're inheriting the IRA, that IRA distribution was appropriately taken by, in that example, your father during that year. 10-year rule. Up until a couple years ago, you might have been familiar with the fact that if you inherited IRA, you could take out the IRA over your life expectancy. That was a significant change that has been taken. If the IRA owner died on or after January 2020, you're now required to withdraw the entire inherited IRA balance within 10 calendar years of the account owner's death, and that obviously means paying the income tax during that time frame, unless you meet certain exceptions. So you've got this 10-year window unless you meet certain exceptions. You could distribute all of it at one time during that 10 years, or you could take out a little bit each year, but at the end of the day, the account has to be emptied by the 10th year following the year of inheritance. So what are some of the exceptions to the 10-year rule? Well, one, if you receive an inherited IRA from a spouse, you can transfer the IRA balance into your own account and delay distributions until your required minimum distribution, which is currently age 72. So if you receive an IRA from a spouse, normally, and it's common planning, you will roll that over into your own IRA so that you don't have to start taking distributions out until you would normally start having to take distributions from your own IRA. If you're a minor child, or you have a minor child who is receiving an inherited IRA, the minor child has to start take minimum distributions out from the time that they receive the inherited IRA, but they're not subject to the 10-year rule until they reach the age of majority in your state, which certainly in the state of Michigan would be 18. So let's say, for example, you have a minor child who's 10 years old and is receiving an inherited IRA. They're going to have to take that IRA out entire. They have to start in year one, but they don't have to complete taking out the IRA until 10 years after they would turn 18, which is 28. So in that case, a considerably longer period of time that the IRA could be there, could grow. But again, decisions are going to have to be made about when. Should it be taken out now? Should it be taken out later? Should a little bit be taken out each year? Certainly something that your tax advisor should be able to be of assistance to you. If you have a disabled beneficiary, all right, so you have a disabled beneficiary who's going to receive an IRA, or perhaps the person is already within 10 years, is within 10 years of age of the original account owner. So let's say the account owner of the IRA was 50 when they died, and the beneficiary, maybe they're leaving it to a sibling who is 45, so that sibling be within 10 years of the age of the original account owner. In that case, you still have the option to stretch required distributions over your lifetime, which is what we used to be able to do. We used to be able to stretch those over lifetime until they shortened it to that 10-year rule. But again, if you have a disabled beneficiary, or the beneficiaries within 10 years of age of the original account owner, you still have the ability to stretch that out over your lifetime. So those are some of the exceptions to the 10-year rule. Another thing to consider is minimizing taxes on inherited IRA distributions. So now when you're looking at the distribution, you need to think about, when you take the money out of the IRA, what is your tax bracket? What is your tax bracket now? What are you projecting your tax bracket to be in the future? For some people, it might turn out that gradually drawing down the account over the 10-year period, so taking perhaps some out each year to avoid a large tax bill at a point in time, would be a wise tax move. It might be, though, for some folks, it's going to turn out because they're in a lower tax year, a lower earnings year, taking more out in a lower earning year, perhaps even taking all of out in a lower earning year might be the appropriate thing. So again, you're going to have to work with your tax advisor. While you've got requirements to make distributions out, let's say over 10 years, you don't have to take them out as a graduated over that time. You could take them all out right now, or it might make sense to stretch those out over that maximum 10-year period of time. So again, it's all premised upon when you're going to take the money out, what tax bracket you're expecting that you're going to be. Again, let's say, for example, you're going to retire in 5 years. And maybe you're looking and saying, okay, when I retire after 5 years, I'm going to be in a lower income bracket. So there, it might make sense to wait until you retire to start taking the proceeds out so that they'll be taxed at a lower tax bracket. Something else that you need to do is make sure you understand that the money in an inherited IRA can be moved to a new financial institution. You can transfer it someplace else. Sometimes people think I'm locked in. So let's say my dad had his IRA through this particular financial institution, and now I'm locked into that financial institution. No, you're not. You can move an inherited IRA to a new financial institution without incurring taxes and penalties, so long as you make what's called a trustee-to-trustee transfer into another IRA that is set up and maintained in the name of the deceased IRA owner for the benefit of the beneficiary. So you're essentially creating a new inherited IRA at another financial institution and having the proceeds directly transferred from the trustee of the current inherited IRA to the new inherited IRA that's been established. Again, you'll still need to take the regular distributions out of the new IRA using the same beneficiary distribution as you had under that original inherited IRA. But the important thing to consider is you don't have to keep it where it is. Perhaps you have a relationship with another financial institution that you prefer to work with. Perhaps a different financial institution is going to offer you more investment options than where it currently is. So you need to understand it can be moved into another financial institution. And something else to think about, if let's say that you have the IRA and you're looking at the beneficiaries that you have, and you're looking at the different ages of the beneficiaries that you have, sometimes splitting the accounts into multiple accounts, i.e. one for each beneficiary. So rather than having, let's say, 3 beneficiaries on your account, you have 3 IRAs, one for each beneficiary. That then allows the individual beneficiary to decide what to do with their own inherited IRA. So it might give them some planning options by splitting up into multiple IRAs during your lifetime rather than having one IRA that's going to split after your death. So those are just some of the rules, things that you need to know if you're receiving an inherited IRA, so that you're going to be in a position to minimize the tax consequence to you of receiving the IRA and receive any penalties for not properly following the rules regarding those distributions that need to be made. Of course, as always, Amanda and I would be honored to have the opportunity to help you protect your loved ones by putting together your estate plan, perhaps amending a current plan that you already have, and even if it's one that we didn't prepare for you, or assisting you in settling a loved one's estate. And just a reminder again, if you have questions about those, take a look at Doyle Law PC at the seminars that are upcoming and join us while we're going to talk about those various topics. But procedurally, we can help you. Just go to the virtual office at doylelawpc.com. There you're going to find a link if you're a prospective client. You'll have the opportunity to set an appointment, download a copy of our free estate planning guidebook. You'll send us information from the guidebook through the website. We give you instructions on how to do all of that. And we'll start out with a Zoom or telephone call normally and talk to you, help you determine what's appropriate for you. And then when documents do get prepared for you, we'll ship them to you at your home, and so that you can arrange to have them executed. If you're a current client, again, through the virtual office at Doyle Law PC, you're going to find an option there for what we call updating my plan. Simply fill out the information in the form, submit that. We'll take a look at it. We will then decide what needs to be done, what changes need to be made to the documents that we already prepared for you. We'll determine if we need to have a consultation. Certainly, if you want to have a consultation, you can schedule that through the website as well. But once we determine if you need to have a consultation, we'll let you know what documents need to be changed and what the cost is of making those changes. And always, if you have simply individual documents, maybe, and this is one that happens quite frequently, you might have a trust, and the trust needs a new certificate of trust. Head simply to the legal store, click on the legal store, where you're going to find the ability to order online various individual documents from us. Or perhaps all you need is a new durable power of attorney, or all you need is a new healthcare power of attorney. Check out the legal store and see if there's see if we are offering that particular document and making it available, and you'll be able to order it online, pay for it online, and we will actually deliver it to you online, which makes the process pretty easy and pretty quick. Well, I think that's going to be it for today's show, although October, snow already in the forecast. I know I am not quite ready for snow. I don't know if you are, but it's inevitable. We live in Michigan, and I guess that's one reason we stay here in Michigan rather than moving someplace that it's warmer. But as always, if you have a comment about the program or perhaps a topic that you'd like to have me discuss, questions that you'd like to have answered, send me an email, tom@tuesdaywithtom.com, or mail me a postcard, Tom Doyle, P.O. Box 3752, Grand Rapids, Michigan 49501. And as always, we invite you, please follow us on Facebook and Twitter at Tuesday with Tom. Follow the office at Doyle Law PC and encourage your friends and family to follow us as well. Remember, too, program is available probably wherever it is that you listen to your podcast, be it Apple Podcasts, Spotify, Google Podcast, iHeartRadio, Spreaker, any number of other services that are out there. We try and have the podcast available on as many of those services that we can arrange it. You can always, too, ask your smart speaker to play Tuesday with Tom. Thank you again, though, for spending some of your time with us today. As always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.